Good afternoon, everyone. I'm Danae Oosthuizen and I'm going to present the conditions of employment at public schools today. So it's still just around 12. I'm just going to go through the introduction and the welcoming before we get into everything. Okay. So the PowerPoints will be sent to all of our member schools in English and Afrikaans at the end of the training. And then today with questions, we'll be dealing with it in the chat function. So I'm going to do the presentation from start to finish without answering any questions in between. We will then at the end have a look at the chat function where we will then, if there's enough time, answer all the questions. If there's not enough time, I'm going to request you guys to just also leave your email address in the chat function with your question, because then we can just send you an email afterwards to ensure that you get a proper answer to your function. Then also just please follow us on Facebook. We share updates there and share some relevant news articles and just exciting things that we have planned for Morrisburg Consultants this year. And then we would also like to inform all of you, we get that requested basically after every training for a video recording of what we are doing now. So all the recordings will be uploaded to YouTube, but it will only be at the end of the series of all of these trainings. So it means only later in February we will upload all of these recordings to YouTube. So you will at a later stage also be able to access them there. So basically today we will be talking about conditions of service in public schools. And what makes this so interesting is that it's not mirroring any other organization out there, if I can explain it like that. The reason for that is that our workforce on a public school ground consists of more than one employer. And these employers are the Department of Education and the school governing body. This is a question that gets asked a lot, is that how is it possible that there can be two employers on the same school ground? And therefore, a few years back, we requested an advisory award from the CCMA to ask them for advice and a legal opinion on this. And this is where they also confirmed in their advisory award that there is definitely two employers on the school ground, the Department of Education and the school governing body. And that is why we have this training today, for me to be able to indicate to you what conditions of service are the same and what conditions of service are different, and where are you allowed to work within this structure. So why can this conditions of service differ between the school governing body and the Department of Education? It's because there are different employers and therefore different legislation applies. So I'm not going to go into details or go into the specific acts to go and read to you what's going on there. At the end of the training with the PowerPoints, I will be sharing relevant regulations and circulars applicable to this if you want to go into more specific details. We will today look at the differences as a broad overview next to each other. So firstly, we will be looking at the legislative differences. What legislation regulates which employees? So I put it for us in a structure like this so that we can see it next to each other. On the left-hand side, you'll see we will be dealing with the school governing body, and that is then school governing body appointments, which can be educators or non-educators. Non-educators can then be your ground staff or your admin staff. So they qualify as non-educators. When we move over to the right side, we will be dealing with the Department of Education, which is divided into two sections, PS appointments and CS appointments. And so just for clarity what that is, CS appointments, curriculum staff is our educators, and the PS appointments, non-educators, will then be our ground staff or our admin staff. So here we look at the difference in the legislative frameworks for these appointments. So when we look at the school governing body, the main legislative framework for conditions of employment specifically is we look at the Labour Relations Act, the Basic Conditions of Employment Act, and then partially we also look at the South African Schools Act. The South African Schools Act in this instance is the basis which allows a school governing body to make certain appointments. But the South African Schools Act also here indicates that the school governing body will then take the responsibility for managing these employees, and that the managing of these employees will then be in accordance with the Labour Relations Act and the Basic Conditions of Employment Act. So that is, if the employer is then the school governing body, that is the legislative framework that you will be looking at when addressing conditions of service or when dealing with employees. Again, I'm going to say that's now educators, non-educators, which can be our ground staff or our admin staff. We look at that legislative framework. If we move over to the right-hand side, the PS appointments and the CS appointments, then there's also a difference in the legislative framework. When we look at the PS appointments, our non-educators, we look at the Public Services Act and then also the relevant regulations that goes with the Public Services Act. Here, what governs the conditions of service is also a bargaining council agreement, partially the Personal Administrative Measures and the South African Schools Act. If we look at CS appointments, which is our educators, we will then have a look at the Employment of Educators Act and the relevant regulations, as well as bargaining council agreements, personal administrative measures, and the South African Schools Act. So the South African Schools Act is something that runs through all three of these categories, where you will see the rest of the legislative framework differs significantly. If we then look at working hours is something that our clients struggle with most. Why? Because we're working with these three categories, it is difficult to just indicate in school context to say that everyone will pitch up for work at 5 and everyone will go home at 8 and everyone will go home at 5. That is almost impossible on a school ground, where we work with these three different categories of employees that plays a different role in the operational requirement of the employer. That's why we are going to look at working hours now. And I'm going to indicate this, that although as a school governing body, we would like to try and treat our employees, the school governing body employees, in the same manner that the Department of Education employees is dealt with, it is also very difficult. We need to remember where the pool of money comes from. I also always explain it like this, to say that if you look at the Department of Education, who pays the salaries? So you can say that the salaries is paid by each and every individual that pays tax, and obviously we can go more into detail there. But then who pays the salaries of the school governing body employees? That is money that is only coming from parents paying school fees. So if you look at our cake or at our pool of money, it's completely different. Obviously the size of our cake or the size of our pool money, it's not on the same level as at all. And that's why sometimes working conditions can differ. Although we try to make it as equal as possible, it is really completely very, very difficult. So again, we will be looking at the same form. We will be looking at the school governing body on the left hand side and the Department of Education on the right hand side. So let's start with the Department of Education. Here, our educators, our CS appointments. This is our educators. They have to work 1,800 hours per year, and at the end of the year they must actually be able to show that they have worked these 1,800 hours per year. They have to work a minimum of 7 hours, or have to be a minimum of 7 hours at work. And if you calculate that over your more or less 200 school days, that equals 1,400 hours. So you will see that we also have 4 hours, 400 hours there that can still be worked. So 80 hours per year can be used for training. And here it's important to note that the principal is in control of the work distribution and the work hours. So there's no set working hours to say that an educator is supposed to pitch up at work at 7 and leave at 2 or 7 till 4. It's the principal of every specific school that will be able to look at the work distribution and the working hours that is necessary for the operational requirements of each and every specific school. And we all know that each and every school, the operational requirements is different, and therefore it is allowed that there is difference in work hours for different schools. When we then look in the middle here, also part of the Department of Education, the PS appointments, our non-educators, our general workers and our office staff, they have to work 40 hours per week. It's a maximum of 40 hours per week. And this is where it differs significantly with the SGB appointments, who can work a maximum of 45 hours per week. Okay, this is something that we can easily say, okay, let's reduce the SGB appointments also to 40 hours per week, but we cannot in any instance increase the PS appointments working hours to 45 hours per week. So if we want to make it equal, we can say we remove 5 hours per work week from the SGB appointments, but we cannot do the same with the PS appointments. And I'm going to just touch the SGB appointments a little later, but on again. So further, for the PS appointments, the principal determines the daily work hours according to operational requirements. Again, here the principal can decide what is necessary and what suits the operational requirements of the employer to ensure that maximum and best performance is given throughout my work week. So the determination and directive on working time in the public service, that's a directive, that determines overtime for PS appointments, and that is a document that I'll also include and send with, because this is also a part where we really struggle, especially with general workers that has to work overtime, let's say due to sport events or something like that. So there is a determination and a directive on the working time in public services, which specifically addresses overtime. But we will be speaking a little bit more about overtime in this training as well. So that is for the Department of Education. So we work with 1,800 hours per year for the employees, for the educators, and we work with 40 hours per week for the PS appointments. So if we now move over to the school governing body appointments, like I've explained previously, it's normal labor legislation that applies. The Labor Relations Act, Basic Conditions of Employment Act, and this is where the Basic Conditions of Employment Act provides for a 45-hour work week. So it's important to note that the Basic Conditions of Employment Act sets out the maximums. So as employer, the school governing body in this sense, we're not allowed to give the employees less favorable terms, but we are allowed to give employees more favorable terms, which is then why employees' working hours can be reduced from 45 hours per week to 40 hours per week. Okay. I know this is working hours, especially with general workers, can be quite tough because we work with, or let's say all non-educators, because these people do more or less exactly the same work, and the type of work where they, let's say, would be in close proximity with one another, and therefore they measure each other a lot. And this is where we really have to explain to our employees that there is 2 employees on the school ground, and this is the reasons why our operational requirements requires that our SGB employees work this conditions of service, and our PS appointments work this conditions of service, especially with the general workers. I think it's very important to at some point just have a proper conversation with them, a proper training with them to show them why certain conditions of service may differ. This is why I work exactly the same or do exactly the same work as my colleague, but my colleague is appointed by the Department of Education and I am appointed by the school governing body, and that is the reason why our conditions of service are allowed to differ. If we look at leave, there is obviously lots and lots and lots of different forms of leave, but for the purposes of this training session, we're going to look at school holidays in respect of annual leave. We're going to look at sick leave, maternity and paternity leave, family responsibility and compassionate leave, as well as special leave. So we're doing it in the exact same framework, and this is something that at a later stage you can maybe, when we distribute it, you can print it out just as a little cheat sheet if there is questions that come in for you to quickly know where I am supposed to go and look and where I can find answers for maybe difficult questions that employees come and ask me. So again, we work in the same format. On the left-hand side, we have the school governing body, our SGB appointments, which is educators and non-educators. So the leave requirements is set out in the Basic Conditions of Employment Act. Okay, this indicates for annual leave that employees should receive a minimum of 15 days, that's working days per year. Okay, so that is not a lot. And if we take it into the context of a school ground and we take it into the context of what my PS appointments are getting and what my CS appointments are getting, this is maybe a place where we can give our SGB employees more favorable terms. Okay, this is a minimum. So the minimum requirement is 15 days per year. So I know, I don't know who of you guys also did our contract training with Anke on Thursday last week. She also went lots more in detail into the specific clauses of our SGB employment contracts. That's why I'm not going to go into detail on the specifics. I'm just merely giving you this as a reference point to see how this compares with one another. So our PS appointments are non-educators. Then we look at the determination and directive on leave of absence in the public services. That's the directive we look at. That's where we will see that annual leave is determined that our PS appointments will receive anything between 27 to 30 days. Leave, 22 of those days must be taken during school holidays, and then the remaining 5 to 8 days can be taken during school terms. This then again also differs from the CS appointments, the educators, that I've indicated here that Chapter H of the Personal Administrative Measures document specifies 12 types of paid leave for educators. And you can have a look at Chapter H of the POM, but specifically with regards to annual leave, employees is entitled to school holidays, official school holidays, and that the principal of the school can request them to undergo specific training with the necessary notice. So again, if we compare these three areas, you will see it's a significant difference between the conditions of service, especially annual leave, between these three categories. My suggestion would always be, remember that if I am requesting employees to work, there should be a manager. And this is where schools sometimes fall into the trap to say that I'm not going to be a very lenient employer and I'm only going to offer my SGB appointments the minimum required 15 days per year. So this is where we have to take it a step further and have to go and look at what will these employees actually do when it is official school holiday. And if I expect my employees to be at work, there must be a manager. So someone who manages them. let's say I expect my administrative staff to be there, and the person who manages the administrative staff is the principal, then it will be expected from the principal to also be present when the administrative assistants, for instance, is at school. Okay, so that's very important to notice, and that is also the same with the PS appointments. Is if I expect the PS appointments to be there and to do their work for the school holidays, where the educators have school holidays, there has to be someone to supervise. Okay, if we move down, we will further look at sick leave. Sick leave also differs between the three categories. Okay, if we look at the Department of Education first, which is the same, then they are entitled to 36 days in a 3-year leave cycle. Okay, so this cannot be every year they start afresh. It's a 3-year leave cycle which provides for 36 days in the leave cycle, start to finish. Employees will have to provide a sick note if they are ill for 3 days or more. So if employees are ill for 3 days, they have to submit a valid sick note. This then, in comparison with the school governing body employees, they receive 30 days, okay, in a 3-year leave cycle. This is something where we cannot specify to say that they get 10 days per year because it works in a 3-year leave cycle. It's specifically indicated like that in the Basic Conditions of Employment Act as well. And sick notes for school governing body employees works as follows. If you are ill for 2 continuous days, you have to provide a sick note. Or if you are ill 2 times in an 8-week period, you also have to provide a sick note. So I know sometimes we want to control these types of things. So if someone phones in with a stomach bug, we don't necessarily believe them, and we will not allow that if that employee, specifically speaking with regards to the SGB, doesn't go to the doctor on that one day illness. So this is important to note, that the Act provides that only after 2 continuous days of not being at work, a sick note is required, or 2 times in an 8-week cycle. This is where, for instance, you will pick up that there is nitpicking leave days. So it's a one day, in order for the employee not to provide a sick note. So that's why the Act also provides for 2 times in an 8-week cycle. And then it's also different when we look at patterns in sick leave, where you will find that certain employees will always be ill the first Monday of a month, or first Friday of a month. So as a part of that investigation of the cycle, we can also then request sick notes. Further, also looking at leave, we look at maternity and paternity leave. So paternity leave is something new and something that has been worked into our labor framework very recently. So you will see that most of our legislation, apart from the normal Labor Relations Act, most of our legislation from the Department of Education hasn't written this into the Act yet, but fathers are allowed to take 2 weeks paid paternity leave, where mothers, specifically employed by the Department of Education, is entitled to 4 months paid maternity leave. This is obviously a huge blessing for people employed by the Department of Education, but it's a trap that we should not fall into when we look at school governing body appointments. School governing appointments, the Basic Conditions of Employment Act indicates that there is provision for employees to take 4 months unpaid leave, and for fathers to take 2 weeks unpaid leave. I've indicated there as unpaid, and you might want to correct me to say that, but everywhere they speak about the 2 weeks paid leave for fathers, if we look at the SGB appointments, but this is paid by the unemployment insurance fund and not paid by the employer. So this is I'm indicating the employer's position here. So the 4 months unpaid leave that mothers are entitled to, they are also during this period entitled to claim money from the unemployment insurance fund. What we have picked up recently is that school governing body appointments have written into their employment contracts that mothers is also allowed 4 months paid leave. Then we have to realize that the payment will be coming from the school governing body, which then provided quite a little bit of problems dealing with COVID at this stage, because like Anka explained in our previous training as well, and I'm not going to go into detail, but you cannot just change someone's contract of employment without consultation and without following the proper procedures. And what has been happening at a few schools is to say that I'm in trouble and I'm just going to stop doing paid maternity leave. And yes, if that falls into the operational requirement, that can be done, but the correct procedure must be followed, okay, which is proper consultation. So just in a nutshell there, Department of Education employees and appointments are entitled to 4 months paid maternity leave and 2 weeks paid paternity leave, where school governing body employees is entitled to 4 months unpaid maternity leave and 2 weeks unpaid paternity leave, which to unpaid maternity and paternity leaves, the employees can claim from the unemployment insurance fund. This is also something I think that we have to explain to our employees, is that when you go and claim at the unemployment insurance fund, you will not receive your full salary. Okay. Further, if we look at family responsibility leave, and at this stage I'm only going to look at the school governing body SGB appointments and the PS appointments, and in the next slide we will deal with educators, because that's been dealt with in a little bit different manner. So school governing bodies receive 3 days for family responsibility leave only if the employee has worked at the employer for 4 months. So this 3 days you're only entitled to after 4 months, and it's also only if you work at least a 4-day work week. The reasons that this family responsibility leave can be taken is if a child is born or sick. So a child is born was normally where a father would have taken his 3 days for when a child is born. So that is actually not necessary, because the Act now provides for paternity leave. Second occurrence is if a spouse, parent, grandparent, adopted parent, child, adopted child, grandchild, brother or sister dies. And you will note this is a very specific list. And this is the only list where an employee will qualify for family responsibility leave. Family responsibility leave is paid leave. Okay, when we look at PS appointments, our non-educators, there's also 3 days that the employees is entitled to, and that is the reasons for the family responsibility leave differs slightly from the SGB employees. So it's also if a spouse or partner gives birth, and like I explained that the SGB employees, this is what we used to use when paternity leave was not provided for. So secondly, it's if a child, spouse, partner is sick or dies, or if an immediate family member passes away. So this is also important to explain to our employees, when am I allowed to take family responsibility leave? You will know that under the SGB appointments, there is no provision for an immediate family member. Therefore, you will not necessarily be entitled to family responsibility leave if an aunt or uncle dies. If you understand what I mean, it doesn't go that far down the line. But it's very important to note that an employer always has a discretion. This is the minimum requirements like I've explained. So employer always has a discretion to indicate that I will allow family responsibility leave in the circumstances as well. But be very careful when we apply our discretion, because when we apply our discretion should also be applied fairly and the same across the board. So I cannot allow one of my close friends, friend employees to take 3 days family responsibility leave if an aunt or uncle dies, but I'm not doing the same for just an employee which I don't consider a friend. It's just an example, but we have to make sure that we deal with our employees in a fair and reasonable manner, especially when we apply our discretion. Okay, so those are the two instances for family responsibility leave for the school governing body and PS appointments. We will now be dealing with family responsibility leave for CS appointments in the next slide. In this slide, I have copied and pasted a part of the personal administrative measures document, because I think this is a area which people get very confused with. So this area is explained as family responsibility leave and special leave for urgent private affairs. So this is a word that you have definitely heard 1,000 times, dringende privaat sake, urgent private affairs, because it's something that is really talked about a lot in schools. But how does it really work? So let's go through exactly what the Act provides for. So an educator shall be granted 3 working days leave per annual leave cycle. And this is now the part that addresses the family responsibility leave. If the educator's spouse or life partner gives birth, or the educator's child, spouse, or life partner is sick. Okay, so this is the 2 instances for which an educator shall be granted 3 working days leave per annual leave cycle, that is per year. An educator, 15.2 year, an educator shall be granted 5 working days leave per annual leave cycle if the educator's child, spouse, or life partner dies, or the educator's immediate family member dies. Okay, so there is 5 days set aside per annual leave cycle for a child, spouse, or life partner that dies, or an educator's immediate family member dying. Okay, so then 15.3 refers now to an institution-based educator. Okay, so it's indicating an institution-based educator may, during a scheduled working period, be granted special leave to attend to an urgent private matter, the nature of which is such that it warrants such an educator's absence from work. Here, it's not specified, it's not indicated what does an urgent private matter indicate, but it must be something that warrants your absence from work. So, for instance, your water geyser bursts and immediately there's nothing else that you can do. You have to go home and go and sort that out. It's an instance that warrants an educator's absence from work. But you will note that under 15.3 there is no daily allocation for that. So if we go to 15.4, we'll note that the number of leave days taken in terms of subparagraph 15.1 and 15.2 shall, in respect of an office-based educator, not exceed 5 working days in an annual leave cycle. Okay, that's not really applicable to us, so we will be focusing on 15.5. The number of leave days taken in terms of subparagraphs 1, 2, 3 shall, in respect of an institution-based educator, not exceed 12 working days in an annual leave cycle. So this gives us the indication that there is, in terms of 15.1, there's 3 days, 15.2, there's 5 days, that leaves us with 8 days. Then we go on that there is an extra 4 days for urgent private affairs. Okay, but that is not necessarily that there is 3 days, 5 days, 12 and 4 days. It's just indicated that these 3 types of leave is not allowed to exceed 12 working days per year. Okay. Then an educator who has used all of his leave in respect of paragraph 15.1 to 15.3, which is now our different types of family responsibility leave and urgent private affairs, that an employee may use available annual leave, including leave accrued in terms of paragraph 15.1, or use up to 184 calendar days of unpaid leave. Okay, so this is exactly the indication for family responsibility leave, with special leave and urgent private affairs. And I think after this you will understand exactly how the Act sets it out. So it's in 3 days, 5 days, 4 days, but these clause number 15 types of leave is not allowed to exceed 12 working days. And that urgent private affairs must be warranted. And if something is warranted, then the principal may request reasonable proof of whatever occurrence is warranting this educator's absence from work. Okay, so now we will be dealing with special leave, and we will divide it in our 3 columns as we've been working the whole time. Looking at the school governing body first. So special leave is not written into normal labor legislation, but it can be granted in certain instances in the discretion of the employer. And it should be dealt with in the employment agreement, preferably. Like I've explained previously, when an employer applies a discretion, it's very important that this discretion be applied in a fair and reasonable manner. All employees should be dealt with the same, and that's why it is very important to deal with this discretion in the employment agreement. If an employer decides that we want to make provision for special leave in certain instances, whether it be paid or unpaid, that those provisions be taken up in the employment contract, the employment agreement, to ensure that the discretion is applied equally. If it's not taken up in the employment agreement, it's not a problem. It should also just be applied with discretion, paid or unpaid. So if the employer decides that I will be, and I'm looking at the school governing body employers here, I will be allowing employees to take certain types of special leave and that it can be paid, then we have to apply that across the board. Okay, when we look at the PS appointments and the CS appointments, the non-educators with the educators, special leave is dealt with in the following manner. So PS appointments, the directive provides that the HOD can adopt a policy on special leave. Okay, but if the principal then receives a request for special leave, it's suggested that it be discussed with the labour unit at the Provincial Education Department. Okay, this is for our non-educators. The POM document actually indicates different types of special leave for educators, for CS appointments. And you will note if you read through the personal administrative measures that there is special leave for quarantine purposes, for professional development and religious purposes. There we have an amount of 3 days. For examination purposes, the day of and the day before the examination. So these type of special leaves is actually set out and indicated in the personal administrative measures. That's why I would suggest that that part of the personal administrative measures be something that you look at quite often, especially if you are working with these types of special leave. Further, now moving on from leave, is disciplinary and grievance proceedings. This is also a part of the conditions of service that differs significantly between the Department of Employees and the school governing body employees. So again, with our 3 columns, we will be looking at what legislation governs these proceedings, and then also just a little bit how the proceedings should be dealt with. Firstly, if we look at the left-hand side, the school governing body appointments, we look at the Labour Relations Act, including all the Code of Good Practices. Here we also look at the Basic Conditions of Employment Act, and then the disciplinary and grievance policy that is supposed to be contained in either the employment agreement, or it should be referred to in the employment agreement, and the policy should be held somewhere where all employees can have a look at it. Okay, it's very important for a school governing body. It's actually very important for any employer, but now the Department of Education has already set out their specifics for the disciplinary and grievance procedure, so that's why I'm only referring to the school governing body now. It's so important for every school governing body as employer to adopt a disciplinary and grievance policy, because this is what will govern how discipline and how grievances will be dealt with, and this will set out a specific procedure for how discipline and grievances should be dealt with in the workplace. So if I maybe can just explain discipline and grievances in a nutshell. Discipline is from the top down. It's where the employer will discipline employees for misconduct. For instance, doing something wrong. A grievance procedure runs parallel. So it can be, or it can be from the bottom to the top. It can be from an employee noting specific grievances against an employer, which will then be from the bottom to the top, or parallel would be an employee noting specific grievances against another employee. And both of these procedures should be adopted in a workplace to ensure proper functioning within the workplace. So we have a concept one that I think most of the schools already have. It's always contained in our employment agreements, but it's so important to go and have a look at it to see what is my school's specific needs and what is my school's operational requirements, and not just to adopt another workplace or institution's disciplinary and grievance policy. Okay, and then lastly, just here I'm making reference to the CCMA. It's indicated that if a SGB employee is unhappy with the disciplinary procedure or the grievance procedure or conditions of service or anything with regards to the employment relationship, the forum where it will be heard is at the CCMA, okay, as general body. If you move over to the Department of Education, where we look at PS appointments and CS appointments, you will see there's once again a difference in the documents that is applicable. For the PS appointments, we look at the Public Services Act, Section 16B and Section 17, that sets out specific type of misconduct and discipline. If we look at grievances, we will look at the Personal Administrative Measures, Chapter H, which will set out the grievance procedure that should be followed for PS appointments. Chapter H sets out the entire proceedings and also the forms, so it's not even a difficult procedure, and it indicates at what different points in time, what different measures should be taken and who should listen to the grievance and what should we do to resolve the grievance. And then lastly, if it cannot be resolved at school level, it will be moved up to departmental level. We also in Gauteng make use of Circular 1 of 2016, which sets out disciplinary guidance and disciplinary procedures for working with PS appointments. And it's also important to note here that you should go and look at the Public Services Bargaining Council Resolution 2 of 1999 as amended in 2003, which also sets out the specific guidelines. So in this instance, if a public service appointment is unhappy with anything in the employment relationship, with the discipline procedure, with the grievance, with discipline, then this PS appointment will go to the Public Services Bargaining Council as forum to listen to that specific matter. Okay, but it's important here to note that as SGB, you cannot discipline or cannot how can I say that? Cannot as employer dismiss these appointments. and that these documentation that I have indicated above has given the principal certain rules, regulations, and guides in dealing with discipline, and allows the principal up to a certain point to deal with discipline at a school level before it's then referred to the Department of Education as employer. Okay, so we have to remember that as employer for PS and CS appointment, that the employer remains the Department of Education and remains the body that has the final say over these employees. Okay, and with that being said, we can move over to the CS appointments to our educators, where we will also find the disciplinary measures set out in the Employment of Educators Act, Annexure 2. For grievance purposes, we will also look at the Personal Administrative Measures Chapter H. Like I've explained previously, Chapter H sets out exactly step by step what to do when facing a grievance. And then also in Gauteng, we look at Circular 1 of 2016, which is a very nice guide, which also gives us templates for warning forms, and which also indicates up until where a principal is allowed to discipline CS appointments, okay, before it is then referred to the Department of Education. And as body, a forum, that the ELRC is the forum which will hear all the disciplinary problems, grievance problems, employment conditions related problems related to CS appointments. So you will even see that the forum for each of these categories differ in that SGB, it's the CCMA, PS appointments, it's the Public Services Bargaining Council, and CS appointments is the ELRC. Okay. Now we're going to speak a little bit about trade unions. The differences, there's obviously differences between GDE and SGB employees, and with how trade unions play a role in that. It's because there is two employers on a school ground, and unions is also employer related. Okay, who can belong to a union? Absolutely any employee out there. It's a constitutional right for any employee to be able to join any trade union of their choosing. We are not allowed to discriminate against them for anything or for joining a trade union. Okay, whose responsibility is it to arrange meetings with the union? That is the responsibility of the employees. There is some confusion sometimes where employees will ask, well, why is the employer, specifically in the instance of the SGB as employer, why is the employer not arranging for me to meet with a trade union? There is absolutely no responsibility or no obligation on an employer to arrange meetings for an employee to meet with a union. Okay, when does a union qualify for a shop steward? So this is, I'm just going to, in a nutshell, because unions can be a topic on its own, but just in short, the union has to gain recognition from the employer. There's a procedure set out in Section 21 of the Labour Relations Act, if we now specifically look at the employer as the SGB. The trade union has to show that on its own or in conjunction with other trade unions that it has members, the majority of the employees in the workplace, and then have at the workplace at least 10 trade union members on its own or jointly with other trade unions. So it's not an instance where I can just say that I've got 10 trade union members and then out of my own appoint a shop steward. The trade union must gain recognition from the employer first with a formal procedure set out in Section 21. Okay, some general problems that we deal with at schools, and at this point there is normally a lot of general problems that we discuss in the employment contract, but fortunately Uncle already discussed employment contracts in detail in our training on Wednesday. So if you've missed that training, it's no problem. Like I said previously, the trainings will be at the end of the series will be uploaded onto YouTube. Then you can just have a look there at the employment contracts. General problems that we also face with is lunchtime, and this is due to the difference in working hours that we face between the school governing body employees, mostly our general and all our non-educators, as well as our BS staff, our non-educators. Okay, we would suggest that you try to make this as equal as possible, and that lunch break is provided as equally as possible. So after a 60-minute lunch break is to be provided after 5 hours continuous working time. Tea breaks do not qualify as a break in working time. So even if there was a 15-minute break for morning tea time, that would not disrupt the continuous working time. The statutory lunch break is 60 minutes long, but by agreement between the employees and the employer, the employee and the employer, this may be reduced to 30 minutes. Okay. The lunch break also does not count as working hours. So if I'm saying that employees should work 40 hours per week, that excludes the lunch break. Okay. So lunch breaks are excluded in determining working hours. This is where I would suggest that you get together with the employees, because in the employment contracts you will have used, let's say, one type of employment contract a few years ago, which indicate that you are entitled to do 15 minutes break and a 30-minute lunch break at certain times. Then a few years later you started using a different type of contract template, which indicated for something completely different, and now you sit with 7 different lunchtime options in 7 different employment contracts. This is where our suggestion is that you call all the employees that should be dealt with equally in together, and you indicate to them, as employer, this is my operational requirement, and you perhaps give them 2 options to decide. Would you prefer 2 15-minute break and a 30-minute lunch break, or would you prefer a 60-minute lunch break, or would you prefer that by agreement we can reduce it to a 30-minute lunch break and then, let's say, go home 30 minutes earlier? But this is something we have to discuss and consult with our employees, specifically if our contracts of employment make reference to something else. Just a touch on overtime. Overtime can be remunerated in terms of time off or paid overtime. Okay, this is important to note. So where there is overtime involved, it can be remunerated on two different bases, which can be time off or paid overtime. So I see I don't have a lot of time left, and I would like to answer the question as well. So I'm just quickly going to speak about housing on state property. Housing on state property always comes in with conditions of service, because my employees will sometimes get the opportunity to reside on the school ground. Housing and residing on the school ground is very clearly stipulated in Circular 54 of 2008. Okay, this circular is very important, and I think the biggest problem that most of the schools are facing is that I just allow housing, or I just allow residing on the school property without the formal